go live button, so let's wait for the stream to fire up across the internet. If you're not familiar with the show, we do multi-stream. Now we're on Facebook, which is up. We're waiting on Periscope. We're waiting on Twitch. And now YouTube is live, so we can get rocking and rolling. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of encouraging some meaningful change. And we're very grateful that you are here and with us on this lovely Wednesday. We've got a lot to get into. Of course, we're going to be breaking down the Derek Chauvin trial. We're on day 3. We have 2 more jurors that were seated. Not sure if there were any more that came after we finished our show prep, but we had a couple motions that were discussed earlier today. And we also had a Supreme Court ruling from the Minnesota Supreme Court that is going to be addressed tomorrow morning in court. So a lot of updates here. We're going to go through some of what witnesses or what jurors were allowed on the panel and the others that were booted off. And so we're going to break that all down. Some interesting stuff there. We're going to change gears, talk about the Qanon Shaman. Remember him from January 6th, the guy with the horns and the spear and all of that stuff. Well, he's been in federal custody for a long period of time, tried to get out very recently, and the judge said not gonna happen. Now, I'm not a big fan of Jacob Chansley, just largely because what he did was not necessarily good for, I would say, people on my side of the conversation. And I still think that he deserves a fair shake. I still think he deserves due process. And what this judge is doing to him is totally inappropriate. So we're going to break that down, and we're going to just show you how we can distinguish this from some other cases and some other protests that are also taking place around the country. Of course, I'm talking about what we saw last summer with Antifa over in Portland, because those were also cases that are being prosecuted by the U.S. Attorney's Office. But for some reason, it seems like the Justice Department, the justice system is being weaponized to be overly harsh for one bucket of people and less harsh for a different bucket. And so I want to break down what that looks like and make sure that we're all up to speed. Then we're going to talk about Brittney Spears. That's right, folks. My first true love, Brittney Spears. She is in the middle of this battle with her father over a conservatorship. And, ordinarily we wouldn't talk about this on this channel, but the House Judiciary Committee is now getting involved. So we have Jim Jordan, we got Matt Gaetz. They sent a letter over to Jerry Nadler in the House of Representatives saying, we want to hold hearings on this stuff, whether or not conservatorships are constitutional, because essentially they are stripping people certain liberties and freedoms to manage their own affairs, manage their own finances and their own livelihoods are being stripped away from them. And so we got to make sure that we call that out when we see it. It just happens to be the beautiful Brittney Spears. So we're going to get into that. And then lastly, since we're sort of talking about pop culture today, we got to revisit the Kobe Bryant helicopter crash. His wife, Vanessa Bryant, is suing the Los Angeles County, I think the sheriff's office, kind of the whole county and everybody involved over there, because after the helicopter crash took place, some of the cops who were there who responded to the scene, well, they took some photographs, and what they do with those photographs, they were sharing them amongst other police officers. That's a big, big no-no. That's an invasion of privacy, total breach of ethical duties. And so she's suing the heck out of them. And she got a big win from the federal judge who said, they can be named. We're going to learn who these people were who were sharing the aftermath photos of the Kobe Bryant helicopter crash. Rest in peace, Kobe. So we've got a lot to get into today. We're going to, of course, answer questions in between those different segments. So if you have a question that you want to ask, feel free to go over to our platform on locals.com. There's a community over there called Watching the Watchers where there's a live chat that takes place. I know we're broadcasting on the other platforms, but really there are people talking on locals.com/watching the watchers where you can go to that site ask a question. Miss Faith, who's right there behind me, will go ahead and clip the question, add it to the slides, then we'll be able to address it. She's also going to post the slides there as well. So if you want any of the information, any links, anything you see in the article, all available over at watchingthewatchers.locals.com, as well as a free copy of my book and some other goodies, not to mention some pretty outstanding people who are talking about these issues. We are going to be on Clubhouse for about half an hour after this show ends, and so there's a link in the description below if you want to join in on that. One more announcement before we dive into it. Faith is in the final running, so make sure you drop her a vote to be the best chef in the whole world, in the whole universe, as a matter of fact. The link down there is below, so I wanted to get that out at the beginning of the show. Go and vote for her. A couple days left on that contest. We want to make sure that she advances into the next round, so show Miss Faith a little bit of love. All right, so let's get into the news. Big story of the day, of course, is the Derek Chauvin case. We're on day 3. We're still in the middle of jury selection, and we've actually got about, I would say, a third of the jury pick. We got 5 people on there. There's a little bit of question about whether we're going to have 14, maybe 15, maybe 16 jurors. And so we're getting close. We're actually filling this up more quickly than I thought we would. And so that's good news. Now, in the middle of the jury selection that was taking place today, the Supreme Court from Minnesota came out and said, well, we're not going to be accepting Derek Chauvin's appeal. Remember what happened here? Let me frame this out a little bit. Derek Chauvin originally was charged with 3 different violations. There was a third-degree murder charge that was dismissed by the lower-level district court judge early on in the case. Just said, well, there's no probable cause for that. The reason why this was even in question is because if you read the statute itself says that in order for somebody to be guilty of that offense, they had to have been causing harm to others with an S. Plural. And here in this case, it was just Chauvin and Floyd. There were no others. It was just Floyd. It was just one person. And so what the lower level judge, Peter Cahill, said that there's no probable cause for this. Well, the government appealed that, and they said, yeah, there is, because others doesn't mean multiple people. It just means one person. So they appealed it to the Court of Appeals. Court of Appeals said, yeah, in fact, you can. It doesn't have to be multiple people, so they came back down. But in the middle of that, Derek Chauvin said, well, I don't like that Court of Appeals ruling, and so he took it up to the Supreme Court. And that's why on Monday, we had all of these different questions about whether this trial was going to continue to move forward. Because theoretically, since that issue was being appealed, you can make an argument that the lower level trial court doesn't have jurisdiction over the case anymore. And in fact, the prosecutor's office was saying the same thing. In other words, they needed to wait until the Supreme Court had made a decision before they could pick back up. And the judge said, no, we're not going to do that. Unless they tell us to stop moving forward on this case, full steam ahead, and they've been doing that. Today, though, we did get a ruling from the Supreme Court. Derek Chauvin was appealing to them, and they said, no, it's denied. We're not going to look at it again. The Court of Appeals ruling stands. So let me show you what that looks like. This article came over, again, from StarTribune.com. They're doing great stuff, and we're going with them as our primary source because they're local to Minnesota. Jury selection was well into the second day today when the state's high court said, without elaboration, I'm going to show you the order here, that it would not hear Chauvin's argument to overturn the appeals court ruling that said a third-degree murder charge against him was improperly dismissed. In other words, it can come back. The judge in court today, Peter Cahill, announced the development Wednesday afternoon, said he would address the matter Thursday morning, so that's going to be tomorrow, when proceedings move towards seating 12 jurors and 2 alternates. So we're looking like 14 total. Prosecutors had argued Monday that the entire trial should be suspended since Chauvin's attorney, Eric Nelson, asked the Supreme Court to intervene. The Attorney General, Keith Ellison, also called the Court of Appeals, filed a motion also asking to postpone the trial until there was a resolution, but no guidance was given, and selection just started. And I think that's to this judge's credit, right? Unless somebody tells him he cannot move forward on this case, Judge Cahill is just grinding this thing ahead, which is a way to handle it. And I actually sort of applaud the tenacity. You know, the whole city's on lockdown or barricaded up, and they've got a lot of provisions out there to ensure that this is a fair trial. They've got a bunch of jurors who've already been questioned and called in. And so this judge is just not letting up. And I think that is to his credit. I actually like that immensely, that he's just driving this thing home. Here is the order from the Supreme Court. We can see here, very, very simple, one-page document filed today, March 10th, in the Office of the Appellate Courts. The state of Minnesota Supreme Court, Minnesota versus Chauvin, says hereby ordered that all of these people for the government can be admitted as pro hoc vice. So you see here, we talked about some of these people, Matthew Frank, of course, Neil Neil Kumar Kadyal, Nathaniel Zelensky. They're all going to be pro hoc vice, which means they're not from Minnesota, but they're going to come into Minnesota and they're going to help the government with their cases. It also says, as a part of this order, it is further ordered that the petition of Derek Michael Chauvin for further review and the same is denied. That's it. Signed off on by the Chief Justice, Lori S. Gildea. So we don't really know what the judge is going to do with this. We do know that the Supreme Court is not going to be hearing Chauvin's appeal. Chauvin obviously does not want an additional charge to be brought out back against him. The Court of Appeals here said that, yeah, the trial court needs to, if the government can sort of re-urge that motion and reestablish probable cause, then they have to follow the Court of Appeals interpretation of that statute. So if the government wants to bring this charge back and says there's enough probable cause to do it, and they believe they can integrate it into their case, the judge sort of has to maneuver around that. And there's going to be some logistical questions that are probably going to pop up tomorrow. I don't know what Eric Nelson's response here is going to be. I don't know. I mean, I think he could easily make the claim that he's not prepared to move forward on that charge. He was only prepared on the first two charges because the other third-degree murder charge was dismissed some time ago. And he could say, no, I mean, I haven't prepared any evidence, any exhibits. I haven't done any interviews for those people. This is a new charge, essentially. And that could really throw a wrench into things. Now, that being said, it sounds like jury selection might actually be done this week. So we have a total of 5. We had 3 that were put on the bench or on the panel yesterday, another 2 that came on today. So if we can get, if they hustle tomorrow, because there were some additional motions that were discussed earlier in the day about training. There was another witness that the government is going to call who is a martial arts person. And he was saying that there is likelihood that he's going to testify about his martial arts skill set and whether or not he would have performed sort of the same maneuver that Chauvin performed on Floyd, whether he would have let off that person, whether he would have done something differently given his experience. As you know, in martial arts, you often use chokes, right, in order to subdue your opponent, especially in Brazilian Jiu-Jitsu and some of the other Jiu-Jitsus. So it's pertinent, it's relevant. They had a lot of discussion about it, and the judge sort of split down the middle on that question. Yeah, he can testify it, but he can't conclude that it was a cause of death, loosely around those lines. So a lot of that was dealt with this morning, which means that it took some time out of the day to pick the jury. Now that some of those questions are out of the way, presumably, well, there's probably going to be more of them tomorrow, but if they can get back on track, if they can really just start grinding through these jurors, we may get close to being done this week. We'll see. Probably not. Probably go into next week. But my point by going down that digression is there is still time. The trial is not set to start until the end of this month. And so the judge might say, well, yeah, we're adding that third-degree murder charge back. You've got about 2 weeks to figure it out. Go get it done. And so I'm not real familiar with the rules of procedure are in Minnesota. Just generally speaking, I don't know whether or not, they have some pretty strict deadlines about bringing charges back or what have you. But the judge is going to tell us tomorrow what he intends to do about it. So interesting news. We may see a third charge come in, which I was expecting anyways. If you go back on the first video that we did defending Derek Chauvin, I went through all 3 of the charges because I suspected that it would be coming back. And here it is. So now he's going to be facing 3. We prepared defenses from my perspective on all 3, and we're going to measure the performance that we see in this trial as it moves forward against sort of my hypothetical predictions. All right, so let's take a look at the layout now. This is back to our court diagram. We can see here a lot of the same parties that we had yesterday, but we do have 5 jurors who are now in our jury panel, and I want to go through them. We're going to go through them. I'm going to show you a couple corrections that we have. So this is what the panel looks like. We know it's now going to be 14 people. We've got 1 through 5 who have been seated. 4 and 5 were seated today. 1, 2, and 3 were seated yesterday. And so we'll see how far we get tomorrow. Maybe we'll get 6, maybe we'll get 7, 8, maybe 9. And then on Friday, maybe we get another 5 if they hustle. So we could get the whole panel seated this week if they hustle. What does the jury box look like? Or what does the courtroom look like? I thought this was interesting. Great graphic over here from Mark Boswell over at the Star Tribune. He put this together. And I wanted to show you what the layout looks like because I think it's interesting. This is a little bit different than what you would traditionally see in a normal courtroom. And you can see how they modified this stuff. So first and foremost, they have the jurors all really separated. And if you look, you can see this is what it looks like. I think this came from within the courtroom where they have something very similar to this. But each juror gets a nice, comfortable chair, which is not normal in courtrooms. Normally they're sitting on stuff that is okay, but it's sort of bolted into the ground. Then they typically don't get a desk. They're sort of writing on their knee. So this is a nice little setup. These jurors are going to be pretty comfortable, and they're also not sitting on top of one another, which is a very good thing as well. Typically, you'll see jury panels where they're just sort of just slammed in together, and that doesn't work if you are in the middle of COVID. So they did some really nice spacing here, and they also have, it looks like, so let me break this down, what a courtroom normally looks like. So I think what they did is they just modified this. None of this stuff up here where the judge is sitting, none of that really moves around. You've got the judge, you've got the witness stand. This, I think, is all built into the courtroom building. And so the witness will walk up this direction and sit behind these glass panels. And so you've got these really thick plexiglass panels that the jury is going to kind of have to look through in order to see their reactions. That's a huge part of a case, is the jury seeing your witness and seeing who's testifying. And so they're going to be looking through a couple big, thick plexiglass panels for some stupid reason, but that's all right. So they're going to do that just so they can play the COVID facade spectacle looking thing. That's fine. They're all following the rules. Happy that the trial is moving on, but is all of this necessary? Probably not, because they're sitting in a building in close proximity. As long as they're healthy and they're testing negative for the virus, I think it's a little bit overkill, but that is what it is. So ordinarily, none of the plexiglass would be here. And I think that, I'm not familiar with this courtroom specifically, but traditionally in courtrooms, at least here in Arizona and some of the ones that I've been in around the country, this jury panel would really be condensed into an area like this. So you'd cram everybody into a little box like this, and then you would have pews or rows sort of in the back that the public can sit in. Then you have the bar, which is, anybody who's a lawyer goes in front of the bar, right? You sort of, in that Jay-Z song, I passed the bar, and that's sort of where that comes from, is passing the bar. So you can go in front and be a part of the court proceedings. At least that's one interpretation of where that came from. And then the public will sit back here and they'll spectate. Well, of course, the public is not going to be available now. Only very limited observers are going to be able to be present in court. So George Floyd and his family, they get one seat. We have Derek Chauvin and his family, they get one seat for the observers. Then we have other pool reporters. We have a technician, very limited for public accessibility into the courtroom. And so traditionally, you would have a podium right there in the middle, and the prosecutor's seat would be over here, and the defense seat would be over here. As I mentioned earlier on this week, Derek Chauvin would really be sitting kind of back over here in the corner, far away from the jury, so that none of his squirming or fidgeting or any facial expressions that he makes are directly visible to the jury, versus if he's sitting right here, then they would be able to see literally everything. So now it looks like he is sitting over here, and his attorney, Mr. Nelson, is sitting over here, and the government's attorneys are sitting back more towards the back of the room, this looks like. So the attorney podium is here, defense and state seating, I believe the state is back here, sort of tucked away in this corner, and so they're going to be able to observe the jury. Eric Nelson's going to be able to observe the jury. We've got a podium here. We've got the court reporter sitting here. And they've just modified the courtroom so that there's more spacing here. They've eliminated the pews. They've sort of rotated the both parties around the courtroom, and it's interesting how they're doing it. Maybe that's too technical and geeky for anybody else out there, but it's interesting from a legal perspective on how they are doing jury trials. Still, jury trials are not happening in many parts of the country. Even here in Arizona, some courts maybe are doing it. We're doing bench trials. We're doing things over Zoom a lot of the time. A lot of court proceedings are over Zoom, but to actually have a full jury and a full courtroom, it's interesting. And so that's how they're going to organize it. We'll see how that goes. Now, let's take a quick look at a summation. So this is a jury table. This is a summation of the different jurors. And you're going to see here, like yesterday, we have emojis to represent the different people. We don't know their names. They're all, of course, under seal. Nobody can know their identities so that they're not being inappropriately influenced. And what we'll see is juror number 1 from yesterday, number 1, 2, and 3. We know that jurors number 1 is a white person. Number 2 is a person of color who's female, unknown, law enforcement uncle, and she is a BLM supporter according. So these are just my notes that I made. Number 3, we learned that today is a white man. Yesterday, we weren't sure what he was. We just knew that he was an auditor. But today, we were able to glean that he is, in fact, a white individual, because when we learned that number 4 juror was also going to be white, there were some comments about that in the media. So number 4 today is a sales data person, and he acknowledged that George Floyd was under the influence and somewhat unruly. So we're going to break that down a little bit further. And then number 5 is an African-American man, a black man, got seated. He's an IT manager, and he's an immigrant. He speaks multiple languages, and he acknowledges that he had a negative view of Chauvin. So we've got, it looks like 3 white males, 1 person of color female, and that's according to their characterization of her. And then we have 1 black male. So it's currently 4 males, 1 female, and we have 3 white individuals and 2 people of color. So, you know, you can draw your conclusions off of that. And let's go through and see some more details. As we recall, number 1, we already talked about him yesterday. Number 2, not much more to report back on her. Number 3, as I mentioned, we said that this person yesterday, we didn't know what race he was. And so now today, this new box was added over on Star Tribune, or I clipped it from there. It says the newest member brings the number of white men on the jury to 3. So the newest member being number 4, which means we conclude that number 3 is one of the other white men. And there was another woman of color there for a trial, and it promises to take substantial amount of time addressing race in the context of a white police officer, detention of a black suspect who died later in that evening. And so we all knew this, that race was going to be, of course, right, an undertone throughout the entirety of this trial. And so, you know, many people are just going to be analyzing the jury just on the basis of race. And in fact, some people might say that the entire decision on this entire case was all about race. It had nothing to do with anything that was presented in the court of law, which I think is not fair. I don't think that's a reasonable perspective on this thing, but you will see people who say that, well, there just wasn't enough black people on there, or there were too many white people, or there weren't enough white people, or what you're going to hear that all throughout the I think remainder of the trial. I don't think it's a fair criticism. We'll see. Everything I've heard thus far, I got to be honest, I think this judge is doing a very nice job of playing evenly to both sides. So number 4, this is the newest member today, first member who got added on. This is another white male. The newest member brings the number of white men on the jury to 3, along with a woman of color, for a trial that promises, as we read. Wednesday's first selected juror said he was not worried about being on the jury during a pandemic or troubled by security in place around the Hennepin County government, but how a trial is poised to eat up most of April that might impact the timing of his wedding set for May 1 in Florida. So he said, if I'm a part of this jury, then I will not be getting married on that date. He said before drawing chuckles, he said, that is me answering, not my fiance. Sure enough, the man was added to the jury, with Judge Peter Cahill offering him with a presumed masked smile, said, go ahead and throw me under the bus with your fiance. So a little fun in court. And we learned a little bit more about this guy. Native of central Minnesota. He is white. Again, everybody's going to be noting this stuff, so just get used to it. Works in sales data, is a father, enjoys sports and music. He saw the video of Floyd's death, reacted negatively. He answered on his questionnaire that he understood that Floyd was, quote, under the influence and somewhat unruly. So that looks like that might be a good fact for the defense, because I think they're going to be trying to show that. It's all about drugs, the ingestion of drugs, fentanyl in the blood, and methamphetamine remnants in the blood, and other medical issues are all probably going to come into play, and this juror is already thinking that way. When pressed by Chauvin's attorney, Eric Nelson, on why he believed that, the juror said, quote, I'm assuming when someone is in handcuffs, they're in handcuffs for a reason, right? And so kind of is making a little bit of a presumption there, which, as a defense attorney, ordinarily you're not comfortable with that. But in this case, the defendant is a cop. So it's actually good for them. So this kind of reverses that. Ordinarily, if somebody is, let's say you have an individual who is charged with shoplifting, and they're being charged with a crime, and they're in the middle of a trial. And a juror comes up and says, well, if they were in handcuffs, they probably did something wrong. Probably a reason for that. As a defendant, you would say, wait a minute, that's totally inappropriate. What about the presumption of innocence? That's not accurate at all. Just because somebody's in handcuffs means they're detained. Doesn't mean they did anything wrong. They haven't been convicted or pled guilty to anything yet. And so that would be a little bit much. But this guy got on the panel. He also said he believes, quote, a police officer is more trained to assess the situation and share it in a court format versus a civilian who might be more emotion-based. I would have another big problem with this if my client were not a police officer, right? To say that in the middle of a court proceeding that a police officer who's a witness is more trained to assess the situation and share it in a court format. Actually, that's not bad. That's not a bad statement. I think I would have less of a problem with that now that I read it again. What I was trying to say is oftentimes what happens in court is you'll have an individual who comes in and says, all right, let's say that the defendant says, I didn't do it, or I didn't see that, or that didn't happen, I didn't say that, whatever it is, and the cop says he did do that. How do you weigh both of those witnesses? Which one's more credible? Well, most people will say the officer is. Because he's a cop. He's in a uniform. He's got a badge. He's got all these training and everything like that. But if it's just about an observation, whether somebody saw something or didn't, they should have the same amount of credibility. And the judge will oftentimes go through and educate people about that. So, no, he's just a witness. You shouldn't give him any more credibility just because he's a police officer. He can make mistakes. He can see things wrong all the time. As a jury, you got to weigh the witnesses evenly. And you got to give him the same amount of credibility. The cop is just a witness, just like other witnesses. And many people don't necessarily know that because it's a cop. So I think he's a little bit off on that, but not in a way that would make this juror struck for cause. I think that this juror can stay on that statement. He says here, however, he marked down the justice system for making, quote, arrests for a small offense like marijuana that are highly skewed toward Black Americans. I wish our country and world would get better at that. I do have belief that people are treated differently because the color of their skin. Okay, so now we've got some statements that the prosecutor is probably going to be very happy with, which is very likely why this guy got on the panel. The defense attorney likes some of what he said. The prosecutor likes some of what he said. He continues, he says, when you look back at the phrase Black Lives Matter, yes, they do matter, and I don't see why anyone would be against that movement, he added, saying that he finds the co-opted phrase Blue Lives Matter in support of police short-sighted, although he does support law enforcement. So you've got some people here on both sides, the prosecutor, the defense attorney, they're hearing things that they like, they're hearing some things that they don't like, and so they're both going to sort of roll the dice on this juror, and he is on the panel. So that's number 4. A couple people got booted off today. They were in court, and the judge said, no, we're not going to let you on the jury. This woman was a white woman. She has lived in Minneapolis for 40 years. She said that she has seen portions of the arrest video, and it left her wanting to know more. She said, quote, there's undoubtedly more information that I don't have, said the marketing professional who grew up in Western Minnesota. Quote, so I am not in a position to judge. There has to be a more of what's going on here. Usually there are a series of events that happen. I would need to know more to have a firm opinion. Question on her opinion of the BLM movement, she said, Black Lives Matter, Blue Lives Matter, all lives matter is the beginning and the end of it. What happened? Well, the prosecution struck the woman from consideration ahead of questioning probably because of that statement, right? That one statement alone where she says all lives matter, I think that's enough there for them to say, all right, that's not a juror that we want on the panel. So the prosecution said, you're out of here. Good move for the prosecution, right? Obviously, they want people who are more, I would say, sensitive to the BLM arguments and more in alignment with that ideology. If they could fill the jury panel up full of BLM people, they would do that, right? And they would win handily. And so they're trying to move that direction. The defense is trying to move the other direction. This woman said that. She's not on the jury. We have another individual. We don't know. We don't have a good emoji for him, but we have the day's third prospective juror, father of 3 girls, said he wanted to be on the jury not only to help deliver justice, but possibly see how public policy might prevent the same result in a similar incident. So I wanted to show you this. This paragraph is basically the same as the bottom paragraph, but they added in who is of Asian descent. So see, we're getting more and more racial identifiers as the story develops. So it said the day's third prospective juror, father of 3 girls. Now it says the day's third prospective juror, who is of Asian descent and a father of 3 girls, said he wanted to be on the jury to help. When Eric Nelson pressed him on that motivation, the man said, quote, the case is the case. As I see it now, policy is not decided here. Policy is decided somewhere else. My duty is only about this case. And as soon as that happened, the defense attorney struck him from a possible seat on the jury. And, I don't really know why the defense attorney did that, but he certainly didn't want him on there, and he will not be. The last juror of the day who is being seated is this gentleman. 5th juror cleared to serve is a black man who immigrated to the United States 14 years ago for school in Nebraska, moved to Minnesota in 2012. He said during questioning that he feels it's his civic duty to be on the jury. He promised that, quote, I will follow the law despite forming a negative view of Chauvin based on seeing part of the viral video of Floyd's arrest, while relating to Floyd's death and saying to the defense attorney that, quote, it could be anybody. It could have been you. The multilingual IT manager also said, I believe that I will be impartial. And so no objections, it sounds like, and we have a fifth juror on the panel. And so this is what it looks like. We are going to be filling up the rest of the seats here shortly, and we'll see what that looks like. It's going to be a busy couple of days. This might spill over into Monday, Tuesday next week, but we'll see. We'll continue to follow along, so please subscribe and join us as this trial continues to unfold. So let's take a look at some questions over from locals.com. You can get there. If you want to ask a question, go to watchingthewatchers.locals.com, sign up and support the show and ask a question. Our first one today comes from News Now Wyoming. Says, if you were the attorney, would you have filed a change of venue? Yes, I would have. I think that they did, and it got denied. I could be mistaken on that. A police station less than 2 miles from the courthouse was burned in the aftermath of the case. Why do you think they didn't? Part one. Part two, could it be possible appeal issue for bad lawyer decisions to not request an obvious change of venue? I feel like I could be off on this. I feel like they did ask for that, or there was something that was done early on in the case and it just wasn't allowed. But I agree. I think this is a very important question here, right? To hold it right in the middle of the epicenter of where this all happened is concerning. And we've actually seen this come up from some of the jurors who were being questioned. I think today there was a juror that I didn't include in my notes here that said something along the lines of, yeah, I mean, I'm concerned about my physical safety and well-being, because what happens if Derek Chauvin's acquitted? What happens if he's partially acquitted? What happens if he's only convicted on this third-degree murder charge and not on the two more serious charges? So he's 1 and he's 2 and 1. Not guilty on 2, guilty on 1. What happens? In the middle of that, it's not going to be good. So, now you have to start thinking about this from that perspective as well. What are the jurors going to do regardless of any evidence that's presented? What are they going to do? What kind of decision are they going to make just to ensure that they have personal safety moving forward? Just to ensure that a year from now, once everybody's identity in this trial is known, once everybody's been doxxed, once all of the information is out there in the public, are they going to have to live looking over their shoulder for the rest of their lives? And that is a real thing. People are really concerned about that. They were talking about it during a jury selection today, and I think the judge even relieved somebody for that very reason. Said, yeah, you're right. If it's too stressful for you, we can't have you here. Because it might cause people to vote one particular way just for the sole reason of ensuring their personal safety. The people who are getting on this jury are taking on a big burden. They're going to have to carry that around for a long time. And that is a pressure that the court has to consider. So News Now Wyoming, I'd have to take a deeper look onto the motion for a change of venue. I felt like I read that, but it has been so long. I think it was something that I read back when these charges were originally filed against the officers. And I just can't recall off the top of my head why that didn't happen. But legal malpractice is kind of a tall order. Derek Chauvin may not have wanted to change it, to have changed the venue. That may have been the discussion that they had, where they would just wait out the pros and cons of it. And he said, no, I want to be here, right? I want to be right here where people know me. There's a jury of my peers, whatever. There's many reasons why you don't change venue, but it is concerning, certainly for the jurors. Now, I think the court's doing a good job. There are barricades everywhere. There's National Guard troops there. I think the last article that I talked about said that they were going to be pulling in officers from 11 different jurisdictions throughout the state to come in and beef up security. But it is a concern. I think it's a very important part of this entire proceeding, which is why the judge is moving this thing forward, because they don't want to go through this all again. Liberty or Death says, the DOJ was heavily politicized under Obama Biden. Now that Creepy Joe is president in public, it isn't going to be any different, even more politicized even. He wrote the crime bill and Kamala prosecuted many under it before working her way up in politics. Who do you think they will come after next? Well, I don't know. I think that there's a lot on the agenda there. I think that anybody, of course, who is connected to the Capitol Hill, they're going to be under the microscope for a long time. They're not getting off easy. We're going to talk about in the next segment, or one of the upcoming segments, about the QAnon Shaman and how I would say, unfair or inappropriate the judge's ruling is in his case. So certainly that's going to happen. I think that they're going to be coming for guns. We're seeing a lot of the racial equity talk. Anybody who is oppositional to that. John Brennan said even libertarians are dangerous. So we'll see where that goes. We have Jeremy Matrita says, I would love to see more about your diagrams of the people in the trial. Those visuals are super helpful for us armchair trial watchers. More about your diagrams of the people in the trial. Those visuals are super helpful. Yeah, so I didn't draw that one, actually. So the one came over from the Star Tribune of the diagram of the courtroom. But yeah, I'm happy to continue to. So we're going to keep playing around with the emojis and the charts. You know, attorneys use a lot of these things in their trial preparation. We make charts. We have jury seating diagrams. As I mentioned on the show, there are even iPad pieces of software that you can use and sort of, keep tabs on your jurors and what's going on in a trial. So I will try to incorporate as much as I can into the show and kind of show you how this would be structured if I was, maybe second chairing or a part of the trial. We have Liberty or Death says, what is the likelihood that if the judge allows the third-degree murder charge and Nelson is not successful in a continuance, once the jury renders their verdict, can the judge issue a directed verdict? So that's a complicated question there, Liberty or Death. Let me read that again. What is the likelihood that if a judge allows a third-degree murder charge and Nelson is not successful in a continuance, once the jury renders their verdict, can the judge issue a directed verdict? So in Minnesota, I don't know the language that they use, whether it's a directed verdict or whether they call it something different. In Arizona, we typically refer to it by the rules. And what Liberty or Death is asking about, and the reason why it's complicated is because I think it's premature to be asking the question because we haven't seen any evidence presented yet. So what essentially what he's asking, when you're in the middle of a trial, I'm trying to organize my thoughts. The government goes first. They have to present their case. If they present their case and they have not established the elements of a crime, so let's say they say, a good example of this might be in a DUI trial. Let's say they go through the DUI trial, they present all of the evidence. They say, okay, well, this person was under the influence and they were driving the car and they hit a tree and they did a toxicology report and the blood results came back and whatever the numbers are, and we have all of the evidence. And you say, okay, that's a pretty good case. But let's say, for example, that they just didn't identify the driver. For some reason, the prosecutor, this never happens, but if the prosecutor just missed identification. So they were talking about a DUI, they were talking about somebody who was driving the car, about an accident, about blood results, all that stuff, but they didn't identify the driver. Well, they're missing a key element of the crime. They've got DUI, they got driving under the influence, they got an accident, all that stuff, but they don't know who the driver was. So they haven't proven their case yet. So at the end of the cases, at the government's case in chief, the defense can say, no, we don't have anything to present. We just move for a verdict. They haven't made their case. They haven't presented anything in court. The judge goes, yeah, you're right. You haven't hit the elements. Sorry. So you haven't stated anything. So the defense doesn't have to present anything. So I don't think that's going to happen here. Liberty or Death. It's a good question. I think that there probably will not be any success in a continuance. I think the judge will just stack it on there and they'll just move this thing forward. Maybe a small continuance. Again, I don't know what the rules are in Minnesota. So, let's say, for example, that there is some sort of provision that says all discovery has to take place no later than 10 days before trial starts. And we add this new charge in and they want to disclose a bunch of stuff, but they're within the 10 days. Then the judge really has no choice but to grant a limited continuance to get back in compliance with the rules. And so we're talking about a lot of different moving parts right now. And I think it's too early to tell. But yes, I mean, the judge could find that if the government didn't present their case, issue a directed verdict or whatever they call it in Minnesota. It's just about, whether, are they going to miss an element like that? Probably not. So the likelihood of that ever happening is very small in my opinion. Liberty says, I haven't heard if Chauvin is a martial arts expert as well. If he is, would seem relevant to have someone like me with 30 years under my belts to testify on chokehold and pain compliance. But if Chauvin is not a martial arts expert, how wouldn't that be prejudicial? I could testify to the custom of martial arts, but if Chauvin is not a martial artist, doesn't seem to be relevant. Yeah, and it's a good question. I think that what they're talking about here was a witness and not Chauvin in particular, but they're talking about what witnesses can testify about. So yesterday we talked about Genevieve Hansen, who is another government witness who is a firefighter. So she is now going to be able to testify about about what she saw and about what she, what her skill set and her training would have commanded that she do, but she can't jump to a conclusion about she could have saved him. So it's a pretty clear line there, and we don't really know what the testimony is going to look like in the course of a trial. Is she going to get close to saying that? This is where defense attorneys here, Eric Nelson is just going to be like this, waiting for this testimony, wait until she says something like that. Objection. We already dealt with that in a motion and eliminate. She's not allowed to do that. And so here they're talking about that same type of thing. She can say all of that stuff about what she observed, but she can't make any conclusory statements about the fact that she believes she could have saved George Floyd. Similar type of conversation happening with this martial arts person, right? If he's going to come to a conclusion like, well, I would have let off of that chokehold and he would have survived. Nah, probably not, because he's not qualified to talk about the possibility of survival. But he might be qualified to talk about how chokeholds work or some of those other elements. And so it's all going to be sort of, the judge is fleshing out sort of the bounds of what the rules are. But when it gets into the specifics, that's where the defense attorneys and the prosecutors are both just on edge, waiting for something that is getting really close to that line that can support an objection. So we'll see where that one goes. Jeremy says, would it be useful to compile data on a police procedure of controlling a person using the same method? How long it's been in use, how often it's used, how many times it resulted in death, etc. Yeah, I think that stuff is very useful. That data is hard. So I've looked at a lot of that data and tried to analyze it and bring it together for the show. The problem with it is it's difficult to find, number one. There are certain studies that exist, but it's hard to sort of correlate data between different departments and summarize it in a way that I think is easily digestible. There are some good studies. I think I posted one over on Locals today responding to another question about the decrease in crime rates. And I think it is useful. I like the data, but I'm not sure that even if we had, let's say, I think the defense could come out and say, we've got data from 100 different police departments. We've got policy manuals that all say that they use this knee on the neck approach. Here are documented reports or policies or manuals or procedure books or whatever that dictate that this should be used. I think that they can present that, or should at least attempt to present it, to show that Derek Chauvin's knee was not outside the norm. It wasn't negligence. It didn't fall below that standard. Therefore, it can't be third degree. It's not eminently dangerous because other departments are using it. And we'll see what the judge does, whether that evidence is going to be admitted or not. I think they'll get that in through the use of expert witnesses. They'll bring in other police officers or other, use of force experts. They'll just have them testify about that stuff. And so rather than coming in and slapping a phone book of reports and Excel spreadsheets and data, you bring in an expert witness, and they're the ones who help explain that to the jury and to the court. Hack Consulting says, does it have to be a unanimous vote by the jury? Yes, it does. How does Chauvin get jury convicted on the charges? What charges are there? Just one, too many? So there are two for sure right now. We have two. There may be a third for the third degree murder, and we'll see if that what the judge does with that tomorrow morning. Yeah, the jury does need to be unanimous. Otherwise, it's going to be a split verdict. That'll be a mistrial. How does Chauvin get jury convicted on the charges? Well, they just present the evidence. The government presents the evidence. The defense presents their evidence. We have cross-examination by both sides, opening, closing arguments, goes over to the jury, and then they issue a verdict. Dr. Renal MD says, Renal MD from New York says, as someone selected for jury duty, do you have to give so much personal data on your background in life? Can you just say, I'm here to serve, but my family and racial upbringing is my privacy? Yeah, I think you can say that. I don't know what the court will do with that. Sort of depends on the judge. A judge might say, well, this is part of your duty. You got to tell us this stuff. This is something that, you're a citizen. We need a jury of your peers, of his peers here. You got to answer those questions, right? You're in court. This is part of the process. Answer them. Or you might have another judge that just says, okay, I understand that totally. Privacy is important. The judge will probably push you on that. So if you got onto the bench and you started to say, I'm not going to answer those questions, the judge is going to grind you a little bit on that. And we saw that yesterday when we had one of the women who didn't make it onto the panel. She said specifically, I can't be impartial, right? Something close to that effect. So I can try, but I can't guarantee to be impartial. And that was pretty unequivocal. And the judge did not let her get away with that, right? He asked her three or four times, are you sure? Let me put it another way for you, young lady. Let me hypothesize it in this manner. And she said, no, judge, for the 50th time, I told you, I can't be impartial. So the judge is going to dig Make sure that there's no possibility of rehabilitation. Make sure they can really get to the root of it. If you prove to be uncooperative, if you prove to be too difficult, and you stay on your, plant your feet in the ground and don't let the judge knock you off base, then maybe the judge will ultimately excuse you. But the judge they don't want to do that, right? They've heard many jurors come into court and make racial comments or say something, hey, my kid's in school or whatever. The judge says, I don't care. I don't care about any of that. Can you be fair and impartial? That's it. You're going to serve. So you could try that approach. I think you'll get different responses from different judges. All right. And our last question, this looks like, comes over from Ryan over at Locals. Says, question for Robert. Given the political environment surrounding the case and the pressure applied to the jurors to declare Chauvin as guilty of all charges, how can we consider this situation where a fair trial could possibly occur? Why isn't there a means for providing protection for the jurors? How is it allowed that a well-funded political groups like BLM can legally influence an outcome of this trial by threat of widespread as well as targeted political violence? So first of all, have they done that? Have they promised a threat of targeted political violence? I don't think that I've seen that. So I'm not sure that that's a fair categorization of it. Now, you can just sort of jump to the conclusion and say, yeah, there's probably going to be political violence, but I haven't seen any sort of explicit threat about that. Now, if that changes, of course, the logical question would be, well, what's the FBI doing about it? What's the U.S. Attorney's Office doing about it? What's the Department of Homeland Security doing about it? And I just don't know that I've seen targeted political violence. It's been implied, but I haven't seen a direct threat of it. It seems to me that we are nearing or have already passed a threshold where our legal system is being compromised by the ongoing threat of what amounts to domestic terrorism. Thoughts? Thanks. So this is a tricky question, right? Now we're talking about people's motivations and some of these sort of implied threats versus direct threats. You've got a lot of people making different claims. You've got a lot of people saying a lot of different things. And so we got to be careful before we start ascribing, one statement to the entire organization. And I've been trying to be consistent about this, right? It's the same principle. Let's take the Capitol Hill riots, for example. What the media did, what I thought was totally inappropriate, is they tried to say that all Trump supporters, anybody who is MAGA, anybody who's a Republican, anybody who wore a hat is an insurrectionist by association, just by implication, just by the fact that they were associated with the Trump brand in any way, shape, or form. That implicates them. I didn't think that was fair, because it's not fair. It's not fair to do that. But we got to apply that same standard over here as well. If there's a couple people saying that they're going to torch the buildings down, well, those people need to be dealt with, but I don't think it's fair to sort of tar and feather an entire movement for the select statements of a few individuals. And it does need to be something concrete. We covered a lot of people from the Capitol Hill riots who were not even there on January 6th, who showed up the day after the fact. They were sending evil text messages. They were saying things like, oh, if I find Pelosi, I'm going to do whatever to her. But that was on January 7th. The guy got arrested the day after for getting into a street fight with somebody over a parking space or something like that. Another guy got picked up because he sent some text messages and he was in possession of ammunition. But he wasn't at the Capitol. He wasn't even involved in it. He was there the next day. And so should we be focusing on that, right? We're seeing a lot of people who are being incriminated and picked up for just being loosely associated with some sort of political movement, which I don't think is right. I don't think that is under anything that the Constitution speculated, that we would be using our justice system to overly politicize and attack what I think is legitimate political protest. And so same in this case, if they're making targeted threats against any of the jurors, or if they're implying strongly, yeah, they need to respond appropriately, and they need to make sure that they are secure and they are safe and that there is no undue pressure on anybody in that courtroom. But I haven't seen much of it, to be honest. I've heard a couple jurors express concern, but the other 5 jurors today, when I was listening in on the proceedings, they all were sort of, it's a high stakes game. A lot of high pressure. There's going to be high pressure. This is the crime of the decade, maybe the century. And it is intense. It's going to be intense. People are going to have anxiety about it. And so the judge is going to allow some of that to go on. But the question is, where does that balance shift? Where does it become, okay, this is just regular high anxiety, high pressure. You're doing your civic duty. Thank you for making the sacrifice in the name of justice. Where does it tip and become something that is now problematic and dangerous, and something that is exhibiting undue influence on the final outcome of the case? right? I'm seeing a lot of people claiming out there that this is not a fair trial. And I haven't seen that yet. From what I've seen in court, this judge is pretty down the middle. I mean, he's doing a dang good job, in my humble opinion, on this case, because he's being even-handed to both sides. I think that certainly there is going to be pressure from the public on both sides. You're going to have jurors who are going to buckle under that pressure. Hopefully not, but somebody probably will. We'll see. It's a good question, and I don't mean to condemn your question at all. I think it's a very good question. And it's a very thoughtful question. I appreciate you asking it. I just don't know that I've seen some of what you have proposed here in terms of what their underlying premise is. But if that changes, I mean, if the head of BLM or somebody from BLM says, unless Chauvin is convicted on all accounts, we're torching Minneapolis, that's a whole different ballgame, right? That's a real threat. And I think that there's some truth behind that. And so we know that the DOJ and U.S. attorneys and Department of Homeland Security and all of the other law enforcement agencies are going hog wild over what happened on the Capitol building on January 6th. We'll see if they apply that same level of scrutiny in this situation. Good question. Thank you for that, Ryan. All right, so that's enough of Chauvin. Let's change gears a little bit. Speaking of Capitol Hill, today we're talking about Qanon Shaman. We're having to go back to January 6th and revisit this case. And as I said at the start of the show, not a fan of this individual, right? This guy did something I think was totally inappropriate. That being said, he deserves due process. He deserves the presumption of innocence. He deserves a fair shake throughout the proceedings in a court of law, and he is not getting that, not at all. And it's reprehensible, actually. We're going to go through an opinion from the judge that I think is grotesque. We're going to get there in a minute. Let's get some background. This comes over from the Post-Millennial. Here is the Qanon Shaman over here. You can see what a dangerous individual this is. I want to draw your attention to this little spike here, because this spike scared the judge, doesn't like it, says it's very dangerous. And apparently, if you have this spike, it's sort of like the ring from the Lord of the Rings. If you have this spike, apparently you have magical powers where you can seize control of the United States government, apparently. Now, he wasn't able to do it on January 6th, but apparently he sort of leveled up his powers. You can see here this vein popping out of his neck. So he is sort of turning into a insurrection maniac, and he's got this spike that he's going to go seize the government. A prominent figure in the January 6th riot, the Qanon Shaman, Jacob Chansley, going to remain behind bars, cannot be placed on house arrest. This judge, Royce Lamberth, made the decision believing that Chansley would otherwise have an opportunity to plot further anti-government attacks, and he's a possible flight risk, even though there's no evidence of either one of those things. The decision came after a purported attack on D.C. was predicted to happen on March 4th, but never came to fruition because it wasn't ever a thing. Court documents reveal a debate among the defense and the prosecution about how dangerous Chansley actually is. Much of the deliberation centered around a 6-foot spear he held during the riot while present inside the Capitol. The judge strongly disagreed with the counter-argument that it was just a flagpole. In the document, the 6-foot pole with a metal spearhead on top was compared to a knife in terms of its danger. The judge says here, quote, both objects have a sharpened point designed to harm by piercing or puncturing. Okay. Prosecution concluded that because the defendant's 6-foot spear is inherently dangerous, it does not matter whether the defendant actually used it to cause bodily harm while inside the Capitol. So basically anything that is dangerous now is a weapon. The court found the defense's argument trying to justify his release inadequate. Lawyers brought up the fact that he lived in Arizona, shout out, his entire life, and that he doesn't have a passport. In addition, the defense leaned heavily on his mother, the fact that the defendant lives with his mother, and that his mother told 60 Minutes that he walked through open doors and escorted into the Senate appeared uncompelling to the court. So he's doing I was just part of the tour defense. It was already open. Chansley's defense team argued that the fact that he published 2 self-help books was enough proof that he's a man of shamanic faith with no interest in politics. All right, so let me give you some background on this. The law states, generally speaking, in Arizona and federal law, that we want to give people the presumption that they can get out of custody. We want people out of custody, just as a matter of policy. Somebody gets charged with a crime, as long as they're safe to the community, as long as they're not a danger to anybody or themselves, as long as they're not a flight risk, we want people to be out. Because the purpose of the justice system is supposed to be about rehabilitation. It's about behavioral correction. It's not in practice. It's really very punitive, as we're seeing here. It's mostly punitive, but it should be And people like to talk about this in fluffy terms and say, well, we're going to, release people. We want it to be rehabilitative. I don't buy that, but in theory, it's supposed to work that way. And so when people get arrested, we want them to get back out of custody so they can get back to school, get back to their families, not lose their jobs. Even if you keep somebody in custody for 48 hours, that's going to wreck a lot of what they have coming in their future. So we want people to get back out. The laws, the rules are all set up to help that. This guy, judge said should not be let out of custody. All right, let's break it down. Let me show you why. This is from the court opinion. After the defendant, so you can see here, this is filed in the district court. After the defendant was arrested on charges stemming from the January 6th riot, he now asks this court to vacate the order of detention and release him as he awaits trial, which could be a very long time. Court held a hearing. They said the court will deny the defendant's motion to revoke the order of detention. The court finds that no condition or combination of conditions of release will reasonably assure the defendant's appearance as required or the safety of others and the community. So they're saying two things. One, if we let this guy out, he's not coming back to court. And if we let this guy back out, he's going to do this again. He's going to injure somebody else. Right? Now, look, in my opinion, this guy was just somebody who was a knucklehead, honestly. Right? What he did was inappropriate. I don't endorse it. I don't condone it. But did he injure anybody? No, not to my knowledge. Did he seize control of the government? No, not to my knowledge. Did he enter into the Senate building in a very sacred place and disrupt a formal government proceeding? Yeah, he did do that, along with many, many other people. And he was eventually escorted out of the building. And that was it. They were back in session in like 4 hours. Okay, not a criminal mastermind, not somebody who shot and murdered somebody. Okay, let's think about this. Many other people throughout this country get bonds. Kyle Rittenhouse got a $2 million bond. Crystal Kaiser got a $1 million bond. Those bonds both resulted in dead people, regardless of what you want to think about those cases. Even Brittney Gosney, who murdered her 6-year-old and threw his body over a river in Ohio, got a $1 million bond, okay? So if she can come up with the money, she can post it and get out. Derek Chauvin was out on bond. He allegedly murdered a man. He got a bond. This guy, no bond. Why is that? Could it be political? Let's take a look. Here it is, the procedural history. So these are the different charges that he's facing. We have obstructing an official proceeding. So that's it. We've got, those are both felonies. We've got disorderly and disruptive conduct in a restricted building, violent entry and disorderly conduct in a Capitol building. We've got parading, demonstrating, picketing in a Capitol building. No murder charges, no dead people. So maybe he should be released because Kyle Rittenhouse is released and there are three people who were killed there. So this is Kenosha, where a judge reviewed the case and said he's free to go, as he should be. In this case, we have a DC judge not going to let out the Qanon Shaman because he had a spike and because he did some drugs. Let's take a look at this. Now, the defendant is asking to be released. He says that Judge Fine ordered him detained. He said there are significant developments which justify the new motion. Those developments, he argued, include the fact that President Biden was inaugurated. COVID-19 pandemic has made it difficult for the counsel, his defense counsel, and him to have unmonitored communication. He said that he wants to be temporarily released for compelling reasons. Currently, his faith precludes him from receiving a COVID-19 vaccination. And the pandemic has made it impossible for the defense and the defendant to speak privately. So a lot of these are the same arguments that you hear. We saw a lot of these arguments in Ghislaine Maxwell's case. Traditionally, these are not justifications for getting out of custody because you and your defense attorney can't communicate well. Well, the judge is going to say, well, figure it out, right? Come down to the jails, set up virtual proceedings. Most jails have mechanisms that help facilitate that. And in this case, they're basically making the very basic rudimentary claims that you would make because he should be out of custody. Let's take a look here. It says the Bail Act, Reform Act authorizes the defendant's pre-trial detention. The government argues the defendant is subject to pre-trial detention because he carried, why keep him? Because he carried a dangerous weapon, a 6-foot spear during the commission of the crimes charged. So he carried a dangerous weapon. So they do not, the government is asking that he does not get out of custody. In response, he said he did not carry a dangerous weapon into the Capitol. It was not a 6-foot spear. It was a flagpole with a spear finial. The spear finial, he notes, is the traditional Native American design. All right, so that sounds reasonable to me. Under this definition, the court finds that the 6-foot pole with a metal spearhead fixed to the top is undoubtedly a dangerous weapon. Like a knife, it is inherently dangerous. Both objects have a sharpened point designed to inflict harm by piercing or puncturing. Moreover, a spear can inflict those puncturing and stabbing wounds at a distance, making it even more effective as an offensive weapon than a knife. Thus, because the defendant's 6-foot spear is inherently dangerous, it does not matter whether the defendant actually used it to cause bodily harm. All right, so, okay. Okay, Judge. This is another paragraph. Now, let's take a look at the history. So, first and foremost, they're defining that as a weapon that justifies not letting somebody out of custody because he had a spear. Okay. Kyle Rittenhouse had a semi-automatic weapon. He's out. Crystal Kaiser killed somebody with a gun, burnt down his building. He's done, or she's out. Derek Chauvin put his knee on George Floyd's neck. He was out. This guy was holding a wooden spear. Didn't even use it, but was in the Capitol building and was part of the MAGA movement. Okay. He has to stay in custody. Is that fair? Let's go look at the defendant's criminal record now. Next, the defendant's history. So the judge will look at this stuff, right? How many times have you been arrested? How many times have you been charged with a similar crime? How many other criminal convictions do you have? How many times did you not show up to court? Let's take a look. The defendant's history and characteristics further indicate that no condition or combination of conditions would reasonably assure the safety of any other person and the community. All right, well, why is that? Though the defendant has no criminal history, the court finds, so that the court acknowledges no criminal history. The court finds his blatant disregard for the law on January 6th to be a telling indicator of how he would act if released. Not only did the defendant have the audacity to enter the U.S. Capitol during a joint session, disrupt the certification, and walk into the chamber, he did so without full knowledge that he was being captured on, on film. He asked, okay, all of that stuff. Furthermore, the defendant's history of drug use and his willingness to lie about that drug use, and yet more examples are of the defendant's willingness to openly break the law. All right, so he's not even commenting on whether marijuana is legal in the state. He's not commenting on whether he was using psychedelics or psilocybin. Those are legal now in Oregon. So he's making a conscious decision now to choose federal law. He's a federal judge in the D.C. Circuit, so he's entitled to do that. But he's writing an opinion here, picking the laws that he wants to make his point. Openly break the law. Well, not if he's in Oregon. Not if he's in Arizona now. You can smoke marijuana, no problem. It says here, pretrial services report said that from Arizona, he says he smokes marijuana 3 times per week. Well, we have medical marijuana here that was allowed back on January 6th, and now we have recreational marijuana, so it's not illegal here, openly breaking the federal law, which is not even enforced. Right? There aren't DEA agents sweeping into Arizona and pilfering all of the dispensaries that we have here. They're all operating normally, functionally. But this judge wants to say that is breaking the law. Okay. And though the defendant told pretrial services that he did not use any other drugs, he's openly stated on his podcast. So the judge or somebody from the court went on his friggin' podcast and said that he uses psychoactive substances and mushrooms as part of his shamanistic practice, which is a religious practice. And the court said that they had to accommodate his diet. I think it was a vegan something diet, based on his religious practices. So the court has already acknowledged that this is a legitimate religion. Why can't he use legal drugs in some states to support his religion? It's because this judge is trying to make a point, and he can do it. The defendant, thus, despite the defendant having no criminal record, the actions on January 6th were not the first time he broke federal law and publicly displayed his remorseless for having done so. I wonder if this judge has ever broken federal law. Do you think this judge ever has? Yes, I would say probably. Right? In many, many different ways. Has he ever broken local laws? Probably. I've made that comment on this channel. You break the law every day. You don't even know it. I could get into a car with any one of my friends and say, law, broken. Right? People do it all the time. Because our laws, our criminal codes, our statutes are like this thick. There are laws for everything. Everything is criminal now. sure the judge is too. Maybe the judge should impeach himself for breaking federal law, for something. Sure, we could find something. Nature and the seriousness of the danger posed to the community by the defendant's release. The nature and the seriousness of the danger posed by the release also weigh in favor of pretrial detention. The court cannot overstate, look how dramatic this is. The court cannot overstate the gravity of the defendant's conduct on January 6th. Were the defendant released pending trial, he would have the opportunity to again attempt to disrupt the United States government or harm members of Congress. Moreover, the defendant's release would allow him to plan with others who might be willing to engage in these acts. So total speculation. Not even any evidence in this. Has there been any evidence? Did the pretrial report say that he was communicating with his comrades to overthrow another government, even though the first one was incredibly a failure? They were in there for 5 minutes before they were escorted out. This judge is just pulling reasons out of the air to keep him in custody, even though people are out of custody all around this country for crimes that are more serious than anything that happened here. Given the nature of this risk, the court finds that ordering the defendant to remain on home confinement would not sufficiently protect the public. Do you feel dangerous from Jacob Chansley? I don't. And although the court could also order the defendant is prohibited from communicating with others via telephone or the internet, the court is not persuaded that the defendant would comply with this condition. Why not? In supporting the finding, the court relies on the defendant's alleged refusal to follow directives from law enforcement officers once inside the Capitol building. His flagrant disrespect for law enforcement indicates he would not adhere to the conditions imposed by this court. So because he broke the law previously, I can predict as a judge that he's going to break the law again, even though he's being monitored, even though he could be a part of pretrial services. The judge could put him on an ankle bracelet. The judge could put him at home where he has to check in with a device that's installed into the wall that's connected to a hardwired phone line. The judge could make him check in, call a number, call pretrial call. There's a million different things that this judge could do. But instead, this judge is going back to January 6th, and because he did not like the conduct so badly, he's just going to make up other reasons to keep him in custody. For these reasons, the court finds by clear and convincing evidence that no condition or combination of release conditions could reasonably assure the safety of other persons and the community. What a joke. For the reasons explained above, the court will deny the defendant's motion for pretrial release written by this guy, Honorable Royce C. Lamberth, the United States District Court judge. Shame that that opinion is a part of a criminal case. And I am, as I said, not in favor of what he did. He made things a lot more difficult for a lot of people in this country. But this is BS. Now, let's compare and contrast this with what the U.S. Attorney's Office is doing in other parts of the country. So here, as I mentioned previously, we have a situation where there is somebody who seemed to be sympathetic to Trump or MAGA or whatever. I don't even know if that's justified. But let's just say that right now, the media, the country is, in my observation, they are saying that anybody who is a part of the Capitol Hill riots or the Capitol Hill protests, those are all Trump's people. Anybody who is a part of Antifa or BLM, those are the left's people. That's kind of the division that I've been seeing unfold around this country. Now, today, both of those political protests have happened. They happened in the Capitol building. They say they're going to happen again. They said they were going to happen on March 4th. That obviously didn't happen. So now they're bracing themselves for whatever the next wave is. I haven't heard of it or seen anything about it or even any murmurings about it. No, nobody's even talking about whatever that is. But we do know that now that there are some protests and some things percolating over there in Minneapolis and other parts of the country. Antifa has still been going at it in various parts of this country for some period of time. Both of those protests should be governed by the same law enforcement agency, by the FBI, if you want to go on a federal level, by the U.S. Attorney's Office. They're prosecuting crimes in both situations. The same U.S. Attorney's Office that reports to the Department of Justice, which is now being run by Joe Biden. They can make charging decisions about what to do. In this case, with Jacob Chansley, they had to want to keep him in custody. They are saying, we're going to keep him in custody. He's too dangerous. If the defense said we want to get him out of custody and the prosecutor said, well, we're not going to take a position on that. We have no opinion on it. Do whatever you want. Or they said, yeah, we're going to ask that he respond to somebody who's a part of pretrial services. We're going to ask that he have an ankle monitor. We're going to make him report home by 8 o'clock at night on curfew, whatever. But that's not what they said. They said, we want to keep him in custody. The U.S. Attorney's Office said this. Well, what are they doing in other cases? There's a great Twitter follow. It's called AntifaWatch 2. They have a nice summary here. Here's a dismissal from the U.S. Attorney's Office over in Oregon of Portland. Here are some Antifa rioters. So this one is Ezra Myers, failing to obey a lawful order, July 24th in Portland. Case dismissed. The United States respectfully requests motion to dismiss the information with prejudice. So this case is dismissed, right? Ezra K. Myers also failing to obey a lawful order. Very similar charges. U.S. Attorney's Office dismissed. It's the 6th dismissal since the inauguration. They've dismissed 23.9% of all 2020 Antifa rioting cases so far. This was posted on January 6th, just about over a month ago. Okay, here's another one. February 10th, this was posted. Here's 2 more dismissals. 25 cases overall. And we got Essence Sylvester. We got Alexis Richter. Also failing to obey orders. Also disorderly conduct. Also on federal property, just like Jacob Chansley. From 10/7, Portland, ICE riot. Both completed a deferred prosecution agreement, which means they did some classes or they did some community service. From what we've seen, less than 40 hours of community service. So it's a slap on the wrist. I'm not saying that this isn't justified. I'm not saying that these people should not have their cases dismissed. I don't know the background of their case. I don't know what's involved. If they can do some community service and have a dismissal of the charges, great. So should the Capitol Hill people, by the way. The ones who, didn't plant pipe bombs. The ones who weren't bashing cops, with flagpoles. Those people shouldn't get a sort of a slap on the wrist. There should be something more substantive there. But these people got their cases dismissed out of the U.S. Attorney's Office. Also for federal riots, also for rioting on federal property, also for disorderly conduct. Major double standards thus far. Let's go back. There's more. It's not just this one. Here's another one. Same from Portland, another Antifa. This one is Jerusalem Callahan. Over here, we've got willful damage to destroy property from a federal courthouse. These riot charges are dismissed. Billy Williams, who leads the U.S. Attorney's Office, resigns on February 28th. They're going to still track this on this thread. So this was posted on February 16th. Another dismissal, government's motion to dismiss without prejudice. So it doesn't even look like that this person had to complete a diversion agreement. This just looks like an outright dismissal. Why? Because without prejudice means that this charge can come back. If you've done something in exchange for the dismissal, they'll dismiss it with prejudice, which means they cannot bring it back against you. So this just looks like a voluntary dismissal in the interest of justice. Dated February 16th. So their case is dismissed. Do you think that they were held in custody because they were dangerous? They willfully damaged and destroyed property in a federal courthouse. Kind of seems like the same level that Jacob Chansley's on. Who's next? Here's another one. We've got Nicholas Kloiber, 26, charged with entering federal property and failing to obey a lawful order. Again, July 23rd, federal courthouse. Also dismissed. Government's motion to dismiss with prejudice. In the interest of justice. Here's another one. Dismissed. Government's motion to dismiss with prejudice. Marnie Samantha Sager, previously Benjamin Samuel Sager, entering federal property, failing to obey a lawful order. Right? And Jacob Chansley still in custody. Other people who were not even in there on January 6th, not even a part of the Capitol Hill riots, as we've talked about, still in custody. Here's the last one. We've got another dismissal. This was posted February 21st, number 29 of 96. First one we've seen on a Sunday, Christine Lisa Margot. She was also charged with entering federal property, failing to obey a lawful order. Motion to dismiss. Okay, so massive double standard here and totally inappropriate. Let's go over to the questions from locals.com over at our Watching the Watchers group over there. Head on over there if you want to join the great conversation. Here's Pinky2 says, do you think it's possible they are keeping some people in jail while this are in social unrest? I don't think so, Pinky. I think this is just purely political. I think that you have DC courts with DC judges who are extremely liberal, who all think that what happened at the Capitol building was like an analog of the Pearl Harbor bombing. And literally, I think Chuck Schumer said something like that. They're talking about 9/11 style commissions. And so I just think the political atmosphere in DC is still so hyperventilating about this entire deal that happened on January 6th that they are just totally out of touch. They're totally out of context, or they're just intentionally being punitive. The judges are being punitive because of the political disposition of the people who were involved. I can't come up with another reason. I mean, if you read that whole opinion, it's It's bad. This judge is twisting himself into a pretzel to try to come up with reasons that, in my opinion, are so speculative. There's nothing that's even based in fact about that, about what he's using as his elements that would justify keeping him in custody. Next question comes over from the doctor. Renal MD says, what about the presumption of innocence? The judge seems to say we are holding him for trial because he's guilty. You're exactly right. You're exactly right. The judge is presupposing his guilt. The judge has already convicted that guy. All right. So if this goes to a trial, he's got to make sure he's got a different judge, that judge is not anywhere near him. There's, rules for noticing judges and things like that. Totally biased. Not even a modicum, not even pretending to be impartial here. Just going through, throwing out a bunch of facts on paper, or a bunch of things a bunch of opinions onto a piece of paper and calling that a political opinion. Nadarb says the shaman was actually one of the few that was trying to get people to leave towards the end while everyone was on the steps. There is no one I despise more than a crooked judge. Yeah, this judge, this is a reprehensible opinion in my opinion, in my humble opinion. All right, Rob, if you had a choice on being the defense lawyer for the Shaman, Kyle Rittenhouse, or Chauvin, and you could only pick one, who would you pick and why? So I would pick Kyle Rittenhouse for sure. Kyle Rittenhouse, I think, is a very important case for self-defense, for the concept of self-defense, for the concept of being able to secure your own life when being attacked. When I went through that analysis on Kyle Rittenhouse, we spent a lot of time talking about his case here. It looked about as clear a self-defense as I've ever seen. And I think that he is absolutely innocent of that. Now, you could have your argument about whether or not he was there or should have been there or should not have been there. But I think that as soon as the situation shifted bad, he was being chased. It was purely self-defense. And that is such a critical line in the sand that I would, if I had to pick one, I would throw all in on the Kyle Rittenhouse case. Good question. We have another one from JBone86. Says, Rob, should the defense counsel file a complaint on judge's politicization of the case against the Q shaman? So, yeah, I actually think so on this. So I know that's not a popular thing to say. A lot of attorneys don't like to say that about judges. But judges are just like anybody else, right? You can file complaints against prosecutors. You can file complaints against any attorney. Go to the state bar, file a complaint. There are judicial boards. There are sort of judicial ethics commissions and groups that you can complain to. And I don't think attorneys do it enough, quite frankly. When you see a case like this, now listen, I don't practice in the DC circuit, obviously. I'm in Arizona. I'm 3,000 miles away. So I don't know what the context there is. Or I don't know if this is just standard operating procedure. If you're charged with a federal crime in DC, does anybody get out? I don't know. I really can't speak to that. If that is true, if this is sort of the common practice out of this jurisdiction, well, maybe I'm barking up the wrong tree. Maybe this is just something that's pretty common. But I can just go around the different cases that we've covered. Everybody's out of custody if they can afford it. So the judge could have said, well, that's $1 million bond. If he can post the bond, then he gets out of custody. Why do other people get that benefit, but he does not? Why were all of those Antifa people, why were their cases dismissed? Very contemporaneously to what we're talking about right now, because Jacob Chansley's motion is also relatively new. So we're talking about the U.S. Attorney's Office is currently making decisions, some about Antifa and those protesters, some about Capitol Hill and those protesters, and they seem to be at different levels. One is very intense, very high bar, very dangerous. We're not going to let you out. Over here, we've got buckets of people who are throwing Molotov cocktails at federal court buildings. Jacob Chansley was holding a flagpole from a Native American tradition that has a spear at the tip of it that he didn't even use. And he's a danger. And because he's mentioned that he does or tried mushrooms somewhere as part of his religion, that is evidence of him breaking the law. It's bad. It's a bad opinion. And I think that if you were practicing in DC, you probably have experience with this judge. You probably know him. You probably have some opinions on him as well. All right. So we got Norovira in the house says, are there any options for us as a society to act to remove bad judges? This is an issue with your next topic. Hashtag free Britney as well. Yeah. So it depends on the different states. Some different states have the ability to recall judges. You can impeach judges at a federal level. You got to impeach the judge. So that judge there would have to go through the impeachment proceedings, the impeachment process in order to remove him. Now you could do some things like if that judge got sanctioned or got disciplined by the Supreme Court or by the Circuit Court or by the federal bar, whatever, then that might cause him to want to resign or step down or just relinquish his practice. But yeah, no, it's a tough thing to do. In some states, judges are just like elected officials. They just run for office. Whoever gets the most votes wins. So in those situations, if you're talking about a state or local level judge, then you could just, run for office, run against them, or support a candidate who is opposed to that judge. But the judges are very powerful in this country, as you can see, right? This is one judge who's really having a negative impact, I think, on Jacob and many other defendants. It's not just him, many other people. And I'd be very curious. I'd be very, very curious to see if this judge has differing opinions or what his history looks like as it relates to release condition motions. So if you went through and you said, okay, judge, we're going to look at all of your motions to modify release conditions, all of your detention orders for the last 10 years. Let's say the last 6 months. Let's say last 1 year. Is there a pattern there? Is this the same across the board? Or is he singling out certain people and trying to make convoluted legal arguments about Spears and recreational drugs that were not even used in this particular case? Pretty ridiculous. We'll see where that one goes. All right, so our next segment. Brittney Spears is back in the news, and this used to be somebody that used to get my heart a little bit of flutter back in the 5th grade days, and so ordinarily we don't talk about Brittney Spears on this channel, but she's in the middle of this battle with her father-in-law over her assets. She's in the middle of this conservatorship, which is basically keeping her hostage to all of the money that she's earned from all of her performance, all of her work, all of her music, all of the things that she's done. It's still sort of subject to her father's whim. This story comes over from thefederalist.com. Representatives now, Jordan and Matt Gaetz, they endorsed the Free Britney movement, and they are asking that this all be heard in front of the House Judiciary Committee. Today, a pair of House Republicans and the Judiciary Committee are demanding that Chairman Jerry Nadler of New York hold hearings on unlawful conservatorships, which we're going to talk about, after celebrity pop star Brittney Spears has remained trapped in an arrangement for more than a decade. A conservatorship is a legal arrangement preserved for those who suffer debilitating conditions, which include severe mental illness or old age. A judge may grant full control of one's daily life, living arrangements, health decisions, and finances to an appointed conservator if the court deems it necessary. In the 13 years since being placed under a conservatorship reserved for those incapacitated, the pop star singer net worth is about $60 million. She's released 4 albums, went on 3 world tours, completed 4-year residency in Las Vegas, starred as a host on The X Factor, made a cameo appearance on Glee, How I Met Your Mother, all that stuff. However, she has made clear her objections to the legal prison restraining her under her father's lucrative command and has stopped performing while in his custody. She has fought the conservatorship in court, which has become the subject of a recent New York Times documentary released in February chronicling the fan-based movement Free Britney to liberate the princess of pop. Here's an image of her holding some sort of award from Fox saying that the Free Britney movement gains momentum. Good for Britney. All right, so this is posted over here from the House Judiciary GOP. So the Judiciary Committee is a pretty important committee in both the House and the Senate. And now we have Representatives Jim Jordan and Representative Matt Gaetz are demanding that Representative Jerry Nadler hold a hearing on court-ordered conservatorships, saying that, quote, the most striking example is perhaps the case of the multi-platinum performing artist Brittney Spears. This is the letter that they drafted over there. You can see this was filed a couple days ago, March 8th, being sent over to the chairman, Jerry Nadler. It says the House Committee on the Judiciary is charged with safeguarding the rights afforded to Americans by the U.S. Constitution. These rights include having the free will to guide one's own affairs and legal autonomy over one's own finances. When situations suggest the unjust deprivation of those rights by the government, we have an obligation to conduct oversight and explore potential remedies. And I'm on board with that. Anytime that I think stuff like that is happening, We do, as a society, need to revisit it. In recent years, there has been a growing public concern about the use of conservatorships to effectively deprive individuals of personal freedoms at the behest of others through the manipulation of the courts. And they reference this article down here. It says it's the U.S. Government Accountability Office, which did a report on guardianships. A project funded by the U.S. Department of Justice to examine the conservator exploitation found that, quote, financial exploitation by conservators often goes unchecked by the courts, and there is a dire need for guardianship conservatorship reform, referencing another article from the National Center for State Courts. Moreover, the ACLU recently voiced that conservatorships should be viewed with skepticism and used as a last resort, but in most cases, it's done routinely and without substantive engagement. ACLU is also concerned that individuals are being, quote, stripped of virtually all their civil rights through guardianships and conservatorships. That's a big problem. Has called for the exploration of reforms to ensure that unnecessary conservatorships can be terminated so these individuals may direct their own lives. The most striking example is Brittney Spears. Since 2008, Ms. Spears has been under a court-ordered conservatorship. The facts and circumstances giving rise to this arrangement remain in dispute, but involve questionable motives and legal tactics by her father and now conservator, Jamie Spears. Let's see if we have a footnote for that one. All right, so in court appearances in August and November, Ms. Spears' attorney represented to the court that Ms. Spears strongly opposed having her father as the conservator, that she was afraid of her father, that she would not again perform publicly so long as this arrangement persisted. Despite these pleas, Mr. Spears remains a conservator of her estate. Despite Ms. Spears claiming to want nothing more than to see despite Mr. Spears, despite dad claiming he wants nothing more to see daughter not need a conservatorship, his attorney admitted in a recent documentary, of the cases I've been involved in, I've not seen a conservatee who has successfully terminated a conservatorship. So they do not want her to get out of it. Ms. Spears is not alone. There are countless other Americans unjustly stripped of their freedoms by others with little recourse. For example, Long Island resident Daniel Gross was forced against his will into a conservatorship after being hospitalized with cellulitis while visiting his daughter in Connecticut. And what the judge labeled as a terrible miscarriage of justice, Mr. Gross was locked in a Connecticut nursing home for 10 months despite his pleas for release. Given the constitutional freedoms at stake and the opaqueness of these arrangements, it is incumbent upon our committee to convene a hearing to examine whether Americans are trapped unjustly in conservatorships. This comes from Jim Jordan, ranking member, and Matt Gaetz, member of Congress. So this is a new issue for me. I didn't even know this was a thing. I didn't even know that that Brittney Spears was going through this trouble. Otherwise, I would have been just pounding the table about this a long time ago. About Brittney. So it's one of those things that is very interesting. I don't know much about conservatorships. I don't practice in this area of law. But when I was thinking about this analogy, I was hearkening back to my days in property law, where we talk about this concept that you do not want the dead hand of the law, or the old hand sort of reaching up from the grave and interfering with your meddling. We talk about this a lot in trusts and estates, that you don't want you don't want your great-great-great-great-grandmother to be able to dictate what you do with your life. In other words, they're only going to give you $1 million of your inheritance if you become a doctor. Right, because then you have to grow up and become a doctor. And so the courts have long said that they're going to sort of prohibit people, or prohibit those types of arrangements that allow that dead hand from the grave to come up and control your life well into the future. Sort of a principle of old property law, estates and trusts and all that stuff. And so this sort of mirrors that in my mind, right? Now we have Mr. Spears, the father, who is somebody who, I think you can make an argument that during Brittney Spears, her early days, may have been instrumental in helping to keep the train on the tracks, right? She's young. We all know that, Brittney was in a little bit of a rocky road there for a little bit of time, right? She shaved her head. She got married. She got that marriage annulled. And so things were a little bit up and down. But now she's an older woman, and presumably she's gotten the help and the resources and the ability to manage her own affairs. Father's not letting it happen. And because this conservatorship was set up when she was much younger, and it's basically bulletproof, maybe there should be something done about that. And I didn't know that this was a problem that was sort of elsewhere around the country. And so I learned something when I was going through this story. My original thought was, why are we talking about Brittney Spears here? but I'm okay with it. I think Britney deserves justice just like everybody else. So hopefully we see some momentum on that. We have one question over from locals.com from News Now Wyoming. Says, it does seem off that mistakes she made in her early 20s before she was even a mother would still give her father full control of her life for so long. A temporary thing during the crisis. Remembering what she was going through, I would understand, but she turned her life around. That's exactly right. And I think that people should be afforded that opportunity. And it's a grotesque tragedy that Britney Spears is no longer performing as a result of this conservatorship. So hopefully she gets out of it. Hopefully the judge sees what's going on. Hopefully these hearings produce something. And remember, this is what Congress is supposed to do, right? They're supposed to hold hearings and investigate these types of claims to see whether or not it justifies legislation that they should pass through the House of Representatives. And so we'll see what Jerry Nadler does. Of course, he runs the Senate Judiciary Committee, and we'll see whether or not any hearings actually get scheduled. So that's it for Britney Spears. Good luck, Britney. Hashtag free Britney. All right. So the last story of the day, the last segment of the day. Some time ago, as we all know, Kobe Bryant tragically died in a helicopter crash along with his daughter and many other people, 7 other people. And as is typical, police respond. It's all routine. It's all ordinary. They got to come to the crime scene or the scene of the accident. It wasn't a crime here that we know of. And it was a high profile case that the whole country was caught off guard. I don't even watch basketball, and I was shocked when I heard that because of the sort of the legendary status of Kobe Bryant and the tragedy that he would die with his daughter. Helicopter crashes, police respond. Unfortunately, police took a bunch of photographs and then they started sharing those around amongst their friends, their pals. Totally inappropriate. You have to understand here that, yes, I know that police are human. They're human beings. But this is a big problem with police. This is a big problem with law enforcement and first responders in general. Oftentimes, their humanity gets the better of them, and they will breach certain ethical protocols, and they'll do things that are wholly inappropriate. There is a right to privacy. You know, if you're in the middle of an accident, if you're in the middle of an altercation, the government just doesn't get to come in and snap photos of everything that's going on and then post it on Facebook. It's not how this stuff works. And traditionally, there are very strict procedures in place that prohibit access to certain data that might be subject to temptation to reveal to the public. And so there was an example here in Scottsdale. I'm not going to name anybody, but there was an individual who used to work for the Scottsdale law enforcement, let's say, and the allegations were that he was dating a woman who got picked up by the Scottsdale police, and because he worked in that agency, when he wanted to know more about this woman, he looked up on public access. Oh, she's got a DUI. Where'd that DUI happen? Oh, out of Scottsdale. Okay, well, I happen to have some access to data in Scottsdale, so maybe I'll just go see if I can take a look at the body camera footage so I can get some indication about what really happened here. Maybe I'll know not to date this person again or whatever. This person didn't have lawful access to that. He wasn't somebody who had the ability to go in and just freely access this stuff because it's segmented out. The body cameras are segmented from certain people. This was not a person who was a uniformed police officer. He just worked sort of in the bureaucracy, and he went and accessed that data, and he got another officer or somebody else to give him access to that data. Well, lo and behold, it is discovered that he had access to that data, and he no longer works over in Scottsdale. It's a big problem. Happens all the time. Cops do this. You know, they'll take pictures of stuff. They'll even text message victims. So they'll go and they'll arrest the boyfriend in a disorderly conduct domestic violence situation. And then the next morning they'll text the girlfriend because the boyfriend's still in custody, and they'll say, "Hey, it's Officer Johnson. Just making sure you're doing okay. You doing okay?" And she goes, yeah, thanks so much. You're my hero, whatever, right? He's creeping on the victim of a crime. This stuff happens all the time. Reprehensible. It's happening to Kobe Bryant and his wife, Vanessa. This article comes over from ABC 7 News. Says here, judge rules in favor of Vanessa Bryant in crash photos lawsuit. Federal judge in California ruled that Kobe Bryant's widow, Vanessa Bryant, can obtain the names of 4 Los Angeles County Sheriff deputies who allegedly shared graphic photos from the site of the helicopter crash that killed her husband, their daughter, Gianna, and 7 others. An effort by the Los Angeles County lawyers to keep the deputies' names under seal. why do they want to do that, was rejected on Monday by U.S. District Judge John F. Walter from the Los Angeles Times. The ruling means the names and the details from the internal affairs investigation of the deputies could be added to the lawsuit against the county and the sheriff's department. I'm going to show you a screenshot of this lawsuit. So she's suing them basically for violations of her right to privacy. The county, however, can appeal the decision. Kobe Bryant and others were killed January 26 when the helicopter they were aboard crashed west of Los Angeles in the hills of Calabasas. The Times later reported that an investigation found deputies shared photos of the victims' remains. Just awful. Vanessa Bryant sued, seeking damages for negligence and invasion of privacy. County lawyers argued that the deputies' names should remain under seal because releasing them would make it easy for hackers to locate their personal information and addresses. So it's very interesting. They want privacy. They don't want their personal information out there. They don't want their addresses out there. They don't want to be located. But when they have a dead girl and a dead basketball player and a dead father, we have a number of other dead people there, they don't get privacy. They're going to snap photographs of them and then pass them around to their friends like this whole is a joke, like they're from TMZ or something like that. It goes on. The judge wrote that Sheriff Alex Villanueva's promise to publicly release the Internal Affairs Bureau report after the conclusion of the investigation undermines the defendant's purported concern in the disclosure of limited excerpts at issue here. The judge also wrote that the public has a vested interest in assessing the truthfulness of the allegations of police misconduct. So they want privacy, but the Bryant family doesn't get any privacy. Let's take a look at this order. Irritates me so much. The United States District Court, Central District of California. This is a snapshot of the lawsuit. I was surprised I didn't hear more about this. So this lawsuit was filed a while ago, and you can see it is Vanessa Bryant here versus the County of Los Angeles. And it's now in the District Court of California. They originally filed it in a state court. This order was released March 8th, 2021. And let's go through it. We have courtroom deputy attorneys present. This is the order denying the joint application for leave to file portions of the First Amendment complaint under seal. All right, so let me frame this out just a little bit. There was an original complaint. So Vanessa Bryant said, after they learned about what happened, the sharing of the photos, the taking of the photos, all of that, they sued. They filed a lawsuit in local state court in California. Then they basically want to refile that complaint or amend it. So they said, well, we originally complained about something. We're going to modify it because we've got some new facts. We've got some new allegations that we want to make. And so now they're communicating with the defendants here would be the sheriffs, and they're saying, hey, we're going to file this new complaint. And they both agree that there needs to be a new complaint that's essentially filed. But what they're disagreeing about is whether the names of those deputies can be in the new complaint. Vanessa Bryant, they want it out there. They want to identify these people. The government, of course, does not. Again, they're concerned about that, their addresses and things like that. They have to be private. It's very sacred that their privacy be upheld. Vanessa's, though, doesn't really matter. So that's the two sides of the argument. That's sort of how they're in alignment. Let's go through the actual order from the court. On February 24th, plaintiff Vanessa Bryant and defendants Los Angeles and the Los Angeles County Sheriff's Department, they filed a joint application for leave to file portions of the First Amendment complaint under seal. So they want to lock it up. So this new amended complaint, they want to keep it under seal so nobody can see what's in it. The court finds that this matter is appropriate for decision without oral argument, so the judge didn't hear from anybody, just said, I'm just going to write a ruling about it. After considering the application and the arguments therein, the court rules as follows. Pursuant to the court order on December 14th, plaintiff's deadline to join parties and amend her complaint is March 24th, which is coming up. Defendants have consented to the filing of the First Amendment complaint. First amended complaint, which adds certain factual allegations and names 4 individual sheriff's deputies, the deputy defendants, and the Los Angeles County Fire Department, the fire department as defendants. So they're going to name them. However, the parties disagree as to whether portions of the First Amendment complaint should be filed under seal and whether the deputy defendants may proceed anonymously. Government wants it to be anonymous. Ms. Bryant wants to have it public. In the application, the government, the defendants, they seek to seal portions of the complaint that contain 2 things. Number 1, the deputies' names and ranks, which the plaintiff obtained from the Internal Affairs Bureau report. And 2, verbatim quotes from the IAB report. So they do not want the names to come out, and they do not want what they said to come out. Defendants refused to produce the IAB report until ordered to do so by the judge. They weren't even going to give it up. The IAB report is subject to confidential designation pursuant to the parties' stipulated protective order. So I would love to know what's in that report. Would love to know what they were talking about. What's in those text messages? What were the images of? I don't necessarily need to see them, but I would like to know what were they of and what were they talking about? Were they laughing? Were they poking fun at this? Were they making racial comments? What the hell was going on there? Why did the Internal Affairs Bureau refuse to release the report until they were ordered? And if they're so concerned about their addresses and their identity and their personal safety, well, why don't they just leave that stuff out? Why don't they ask that their names be left out? But shouldn't we be able to hear the quotes? So if we don't know their identities, if they remain anonymous, well, we should still be able to know what the quotes are. What is knowing what the quotes say? How does that impact their privacy or their dangerousness? Do they identify their names in the quotes? Hey, this is Sergeant Johnson sending you an awful text message to Sergeant Mary. Okay. That's going to reveal who they are? It's because it's awful. They don't want you to see it because this is what police do. They just bury everything. You got to have millions of dollars in lawsuits to go even get access to it. Vanessa Bryant does. She has the ability to do this. You don't. I don't. We do. We have a law firm here. But individually, you understand my point. Most people do not. She does. Good for her. Historically, courts have recognized a general right to inspect and copy public records and documents, including judicial records and documents. The court is citing Kamakana versus City and County of Honolulu. Big wall of text here. We'll go through it quickly. In considering a sealing request, the court begins with a, quote, strong presumption of access from the starting point. Because a complaint forms the foundation of the lawsuit and is a document that is more than tangentially related to the underlying cause of action, parties seeking to seal a complaint must articulate a compelling reason supported by specific factual findings that outweigh the general history of access and the public policies favoring disclosure. So the judge is saying, look, it's a complaint. It's the basis of the entire lawsuit. Everything that we're complaining about in here is coming from the complaint. Every other order, every other calendar, every other settlement conference, every other disclosure request, all oral, it's all based out of the complaint. If the complaint's not public, why the hell do we care about what else is out there? We don't, because we don't even know what they're talking about. So the judge is citing some case law and referencing the fact that public policy and the presumption here is that this stuff is made public. If the government wants to keep it sealed, they got to come up with compelling reasons. They got to come up with factual findings that outweigh the general history of access. The presumption is it's open. Government, it's your burden to come and show us why it should be closed. And it's got to be compelling. In general, compelling reasons that are sufficient to outweigh the public interest and justify sealing the court record exist when such court files might have become a vehicle for improper purposes, such as the use of records to gratify private spite, promote public scandal, circulate libelous statements, or release trade secrets. However, the mere fact that production of the records may lead to a litigant's embarrassment, to their incrimination, or to their exposure to further litigation will not, without more, compel the court to seal its records. Okay, it's got to be one of these things. Otherwise, not good enough. Defendants have failed to demonstrate compelling reasons to seal the deputy defendants' names and ranks or the verbatim quotes from the IAB report. Indeed, where the case involves allegations of police misconduct, the public has a vested interest in assessing the truthfulness of the allegations of official misconduct and whether agencies that are responsible for investigating and adjudicating complaints of misconduct have acted properly and wisely. Misconduct by, and look at all these sites. Just, I love this judge's home run right here. Misconduct by individual officers, incompetent internal investigations, or questionable supervisory practices must be exposed if they exist. With respect to the defendant's request, the sheriff's request to seal the names and ranks, defendants have not identified a single case in which a police officer sued for civil rights violations has been allowed to proceed in such a manner. In which a police officer sued for civil rights has been allowed to proceed in such a manner. So they're not identifying any other precedent. Although the court recognizes that this case has been the subject of public scrutiny and media attention, and that the deputy defendants are legitimately concerned that they will encounter vitriol and social media attacks, such concerns by themselves are not sufficient to outweigh the public's strong interest in access. Moreover, defendants' concerns that hackers may attempt to seek out and gain access to their individual deputies' devices to locate any photographs and publish them is totally inconsistent with their position that such photographs no longer exist. Oh, this judge is just money. We just heard from another judge, not too good. This judge, pretty good. They're saying, well, we can't have this information out there because hackers might get access to the phone and release the photos. And the judge says, hang on a minute there, buddy. You already said that there were no more photos because they were all deleted. So which is it? Huh? Pretty good there, Judge. Here it says, with respect to the verbatim quotes from the IAB report, defendants argue that publicly disclosing these quotes will, quote, discourage witness cooperation and prevent the IAB from fully investigating potential misconduct. However, this type of conclusory assertion does not satisfy the compelling reason standard. As the district court stated in Macias, contrary to defendants' assertions otherwise, courts have recognized that victims, witnesses, and other officers may be more likely to participate in investigations or discipline proceedings if they believe their reports of misconduct will be thoroughly and fairly investigated. Moreover, Sheriff Villanueva's promise to publicly release the IAB report after the conclusion of the investigation undermines the defendant's purported concern in the disclosure of the limited excerpts at issue here. For the foregoing reasons, the defendant's application is denied. I'm happy with this judge. Like this judge. Very good stuff there. This happens all the time, and most of the time it actually goes in favor of the officers. They get to protect everything, right? Everything is held under seal because they're so scared of everything. They harm something, they do some harm out in society, and then they sort of crawl back into their circle of blue shields that are protecting them from any repercussions from the public. Now today, the judge says, no, you did that. Public needs to know. It's a part of the complaint. It's open for business. And Mr. Government, if you're concerned about this, about hackers getting the photos, well, you already told us that the photos were deleted. And by the way, your own sheriff said that they're going to release a full report anyways. And so why are you so concerned about these bad quotes? What are you talking about? It's going to discourage witness cooperation. What the heck does that even mean? They're quotes from your defendants. Are you going to investigate? Are you saying that your investigation, your internal affairs investigation is going to be a problem? What are you talking about? None of that serves Vanessa Bryant. Vanessa Bryant, to her credit, is driving this bus, driving hard. Good for her. Good for this judge. Makes me very happy. Good way to end the show. Question on this comes over from Norovira. Finally, the police is sanctioned for this. Number one lesson is that when people are in difficult situations and are facing death and illness, their pictures should not be shared. How is that not common sense? I hope Vanessa Bryant wins this. And it's looking like she will. I think that she will. It is reprehensible. Look, I understand that if you are a person, a human being, that you get a little bit of celebrity energy. People just sort of drool all over themselves to be around celebrities. People want to be on the Derek Chauvin trial. I'm so excited to be here, juror number 3 said. Okay, you're going to get on the jury panel. That's fine. Cops are not different from humans. They're human beings. And so they're going to get caught up in the moment. They're going to take pictures and they're going to do bad things. Totally reprehensible. I do not condone it at all. The reason why cops go through the training and they get, they go through their academy and they get their badge is because we hold them to a higher standard, as we should, as lawyers do and doctors do. In certain professions, you just got to know better. And if you cross that line, this is a major one of those lines, totally inappropriate, should never have happened, really reprehensible conduct. The dead should be able to rest in peace. They should not be the subject of profane text messages that are being sent around this country. Not okay at all. They probably would have gotten away with it if it were not for Kobe Bryant. They would have gotten away with it if it were not for Vanessa Bryant, rather. Driving this home, and the judge is in alignment with her. Big victory on this, and I hope the sheriff's office has a penalty to pay for that type of conduct. And what irritates me even more about this, to be fair, if they would have just said, yeah, look, we have these 4 deputies, idiots, we're going to discipline the hell out of them. They're all going to be suspended, or they're going to all be pulled off duty, or they're going on a desk for 6 months or whatever. They're going to be disciplined. We're going to deal with this internally. Here's all of the information. Here's what they said. Here's how they said it. Here's full transparency. We're going to open it up to the public, and we're going to make sure that the accountability is passed on to the people who are responsible for this egregious offense. I'd be like, okay, there you go. That's good. And I would say probably shouldn't even sue them for that, right? Let it go. They've owned it, but they are not owning it. In fact, they are doubling and tripling down on this. We're not going to release the names. We're not going to release the quotes. We're going to fight with the release of the report. I'm sure they're going to do that. Sheriff Villanueva is going to order it, and probably they're going to redact a bunch of stuff for public safety. It's going to be a whole rigmarole. Around and around we go. That's even more offensive to me. It's the cover-up that drives me bananas. I understand that cops are going to make a mistake. I understand that they're going to get caught up in the fervor and the fury and the emotion of the scene. I don't agree with it. I don't endorse it. I think they should still be punished for that because we expect more from them. But I understand it's going to happen. As long as they own it and they try to remediate it, we can't be too upset about that. But when they then double down, no, we're going to hide them, and we're going to make up all these BS reasons for hackers and cooperating witnesses. It's BS. It's total BS. And they know it. But they're doing it to serve their people at the expense of the public. And that is beyond reprehensible in my opinion. And the judge seems to agree. So we'll see where this one goes. All right. Good questions today. Want to thank all of those of you over on Locals who are supporting the show. Many of you make this show possible. You keep our energy high. We got Hack Consulting in the house. Jason Segal. We got Dr. Renal MD from New York who chimed in on today. We've got a couple others. Molly May _shades. We have Want to Know. We got Danny Girl. Just like to say thank you to all of these tremendous people. Nadarb Lasir was in the house today. Who else do we have going on? Darker _1992. Carolina Flying, I call a lot. We got some new people who signed up. What's up? J-Bone86 joined up. Welcome to the crew. We got News Now Wyoming in the house. We have Danger Mouse Girl in real life. I'm sorry. Yeah, Danger Mouse in real life. And then we have E2V. E-ta-T. Ito the. Welcome to the show. Welcome to the program. All of those people are over on locals.com along with Anki Woe. We've got Remark number 2. Zuck's in the house. Norovira. Saw her today. Good to see you, Norovira. And there's a lot of great stuff over there on locals.com. I'm trying to post more links over there. Eventually, when I sort of get back into the swing of things here in terms of my content production, I intend to release some more videos just exclusively over to Locals. And so we're working our way over there, but I'd encourage you to go over there now because there's some pretty great stuff. Get a copy of my book. It's free. PDF available to download. Get a copy of the slides as well. Get a copy of any impeachment party templates that you'd like. Grab a copy of my existence systems. I just gave a talk on this, in fact, to a friend of mine's company yesterday. It went very well. People seem to be appreciative of it. People are liking it. So go check that out. We share good links over there and have great conversations with great people. So check out locals.com. It's a platform where we can have a little bit more free speech without being feared, having the fear of sort of being canceled at every single turn on some of the other platforms. So check it out. Would be very much appreciative if you did. Lastly, but not leastly, I am a criminal defense attorney here at the R&R Law Group. We're in Scottsdale, Arizona. We love to help good people who have been charged with crimes find safety, clarity, and hope in their cases, but beyond that, in their futures. We offer free case evaluations. We can help anybody with any type of criminal charge in the state of Arizona. I'm talking about things like DUIs, domestic violence, drug offenses, any of the old town crimes, things like disorderly conduct, urinating in public, criminal damage, criminal trespass. Things are opening back up in this country. There's going to be some more of that, along with the DUIs and some of the other offenses. We also handle felonies, major felonies involving some of the most heinous things that you can think of. We've covered those and more, anything and everything in between. So if you know anybody who wants to clear up a criminal record, whether it's a current case, an old case, we can help people restore their rights, restore their right to possess a firearm, restore their right to vote, federal benefits, and the list goes on. We help people remove mugshots. We help people quash old warrants. And there's a lot that we can do. You know, a lot of people think that if you've been charged with a crime, you're automatically guilty. And that's the end of the story. And that's just not the case. There's a lot that we can do to make sure that you come out even better than we found you, even better than the system would certainly want to do to you. We don't want you to go through the justice system and come out the other end sort of ground into a bag of dirt. It's not okay. We think that the justice system should be a lot more humanitarian and really help people get things back on track. And we, of course, want to assist in that process. So if you happen to know anybody in the state of Arizona who needs help with a criminal charge, send them our way. Free case evaluations. We would be honored and humbled and grateful for your referral. And that is it from me, my friends. We are going to hop on Clubhouse. I've got about half an hour on Clubhouse that I can devote to answering some live Q&A. We have a lot of fun there. We have a community over there now on Clubhouse called Watching the Watchers. It's a club. It's an official club. So if you want to check that out, please go on over to Clubhouse. I know it's iPhone only. I know it's problematic to those of you with Androids. What I did personally is I went out and got an iPad, a separate device, but you could easily use an old iPhone, or there are even, iPod touches, I think, that are $199 on Apple if you want to just buy a Clubhouse device, especially if you are somebody who likes to talk, who likes to communicate, who wants to sort of be on the latest tech, be a part of a new growing, burgeoning social media platform. You may want to check it out. If not, they're working on an Android app. So soon enough, we'll be able to unveil that to everybody. Before we sign off, one more reminder to go down below and vote for Miss Faith. She's at the last little hurdle on her competition. She is the best chef in the whole planet. And if you don't vote for her, she'll slice and dice you, folks. So proceed with caution. Go down there and vote on that link below so that we can help advance her to the next stage. I would be personally thankful for you, appreciative of you if you went and did that, because Faith is awesome and she deserves it. And while I'm shouting out, what's up, Ma? You're also awesome. We're going to see you on Clubhouse here soon enough. Everybody, thanks so much for being a part of the broadcast, being a part of the program. I'll be on Clubhouse right now if you want to come and join us. Otherwise, we'll see you right back here tomorrow, same place, same time. It's going to be 5 p.m. Arizona time. Oh, I got another announcement, by the way. So speaking of times, apparently daylight savings time is a thing still. I thought that maybe this country would finally mature out of this insanity. I don't know what it is. I don't know why we do it. It's asinine. In Arizona, we don't change the clock, okay? We're adults here. We just let it go. I don't know what the rest of this country is doing, moving their clocks around. That being said, we're not going to change the time of the show. The show is going to carry on, as it were, for most of you in the other 49 states. If you're in Arizona, we are going to move the time back so that we can still be broadcasting at 7 p.m. Eastern Standard Time or Eastern Daylight Time, or whatever the heck is going on with the clocks around this country. Apparently that changes on March 14th. So it's the show, if you're in Arizona where we don't move, the show is going to go earlier, an hour. I think that's how that works. So we'll be starting in Arizona at 4 p.m. As soon as daylight savings time switches. But I think for the rest of you, that stays the same. Faith and I were trying to figure this out, but it's way too complicated for us. So we're going to figure it out when it happens. So that's going to be the time change announcements. For most of you, it's probably not going to impact you at all. Until that happens, it is still the same place, same time, same location, 5 p.m. Arizona time, 4 p.m., which is Mountain Time, 4 p.m. in California, which is Pacific time, 6 p.m. Central in Texas, 7 p.m. in Florida. And for those of you on the East Coast, everybody have a lovely evening. Sleep very well. I will see you right back here tomorrow. Bye-bye.